Okay, I think we'll go ahead and get this started. I'm just looking for a heads up that sound is all working okay. Okay. Give us 1 minute here. We lost our PIO, and so there's a bunch of engineers trying to figure out how to run a public meeting. Okay, I got the thumbs up. All right, first off, thanks to my people that we've all kind of pitched in on this one to make this public meeting happen and still keep up our live streaming, and so I thank each and every one of them. My name is Michael Drake. I'm the Assistant State Engineer over the Adjudication section, and we're here today to talk about the Fort Union proposed determination. This is the latest subdivision that we've published. It's part of the Utah Lake Jordan River adjudication. And we've been publishing subdivisions as we go. We're down to the last few in Salt Lake County, and so it's kind of fun to be close to the end here. We're still causing trouble down in Utah County and Wasatch County, and so you know we still have plenty of work to do, but we're excited to be close to the end. So just FYI for people online and in the meeting, we are recording this meeting. And are they going to be able to hear you online? They should be able to. Using that microphone. No, we're not using this microphone. I have a little clippy right here. Yeah, no, I appreciate it. As I said, a bunch of engineers figuring out how to run a live stream, so we appreciate the help. All right, so let's see. So we are recording it. This will be made available later on our YouTube channel, and so you can revisit this and listen in. And let's see, then it's live streamed. And so for those that are online, welcome. So the goal of this meeting, this public meeting is maybe a little different than a lot of the public meetings that are held in this room across the hall. It's not like a city council meeting. There isn't really like a public comment period or anything like that, but we are here to answer questions and we're here to inform. That's our primary objective. And so kind of with that, we'll talk about, I guess, with a few introductions. I have several of my staff members here. We also have a representative from the Attorney General's office, Mike Ferguson. He's in the back. And so if you have legal questions, we can certainly tap into the Attorney General's office to help us out on that. All right, so moving on here, what were we going to talk about? So we are going to go through real quickly, revisit the adjudication process. We talked about this in our prior 2 public meetings on the Fort Union proposed determination. We're going to talk about how to access the proposed determination and the hydrographic survey maps that were prepared jointly and with this. And then we'll talk about kind of a historical analysis of the proposed determination, some of the assumptions that were made to get us to this point. The Little Cottonwood decree has been a very challenging decree to interpret, and so we've put a lot of work into that, and we'll go over some of our assumptions that get us to this point. Some of that will take us into one of the later books that we're going to be doing, the actual Little Cottonwood proposed determination, which is forthcoming. It's in the final stages of preparation. And then we can take questions if anyone has any questions. All right, so with that, we can take questions electronically as well. You can see the email is on the screen, waterrights_adjudication@utah.gov. That email address gets forwarded to me, and so that's a good way to contact me directly. And we can certainly reach any of our other staff members through that email address. Okay, so let's talk real quickly about the general adjudication, what it is, why we do it. It is an action in district court. All right, and so this is a legal process. We commence it with a summons, and there is a notice to file claims, and the idea here is that we join all water users and the state engineer into a judicial proceeding. And the objective of that proceeding is to determine all of the water rights in the area. It's all governed by Title 73, Chapter 4 of Utah Code, and that lays out how the adjudication proceeds. And And so why do we do this? Well, there's a few reasons we do this. In the state of Utah, if you know your Utah history, pioneers came in 1847, started settling the area, started diverting water. It was 50 years later, roughly, that Utah became a state. The very first water statutes, didn't hit the books until 1903. That's a long period of water development, and all of that happened pre-statutorily, prior to Utah's water laws. And so what they contemplated back in that day is that adjudication would be the way that we would bring these pre-statutory water rights onto the records of the state engineer. In this area, we have a very important thing, the Little Cottonwood Decree that was entered by Judge Morris back in the day. And so we've had to interface with that decree as we prepare this general adjudication. Another reason, and this doesn't, well, I guess it does apply, we have one reserved right in the Little Cottonwood, the forthcoming Little Cottonwood proposed determination. So we won't talk about that much here, but normally adjudication is the way that we bring in reserved rights, federal reserved rights. Adjudications tend to avoid extensive litigation. It does bring on litigation, but we tend to be able to put to bed some of the long-standing issues that are in the area by determining the water rights with more certainty. And then we also look at and evaluate water rights that are not being used, and we may remove them or reduce them through forfeiture. And at the end of this, we petition the court for a final decree, and that's kind of the gold standard water right, if you can get a decreed water right. Ultimately, we'd like to get the entire state to that point, and we're working hard at that. And like I indicated, we're really close to a really important benchmark on Salt Lake Valley, on the Salt Lake Valley adjudication area. Okay, so let's talk about the adjudication process. We have moved through a significant part of this. You can think of it in three different phases. The colors represent the three different phases, and we started this a long time ago. The original petition was quite a long time ago, back in 1944. This particular subdivision, and we break up the area into subdivisions. It would be very overwhelming to try and adjudicate the entire Utah Lake Jordan River adjudication all at once. And so we break it up into bite-sized pieces. That bite-sized piece here is the Fort Union proposed determination. So we commenced this subdivision in June of 2018, and a summons went out at that time, and a public meeting, an initial public meeting was held, and then a notice to file claims was sent out. And that started a 90-day period in which we received water user claims. We compared that list all of those water user claims to all of the known water rights, and we identified which rights had not been claimed. We put those on what's called a list of unclaimed rights. And we filed that with the district court, and people were given an opportunity to object. And if people did not object, then those rights were abandoned. And there was another public meeting held that was just prior to that, or at the time of the filing of the list of unclaimed rights. What we've been doing since then was we've been investigating claims throughout this entire period. And we're at the point now, we filed the proposed determination in this area, and that started another 90-day clock, a 90-day deadline to file an objection. And so we're here to talk about that today. This is the final public meeting in the adjudication process. At the end of the 90 days, we'll evaluate what objections we receive, and that's the point where we will begin to work through the objections through resolution. And at the end of that, we will petition the court for a decree on this subdivision, and that's the end of the road as far as the process is concerned. All right, so let's talk about real quickly how to access the proposed determination. We sent out notice a few weeks ago to all of the water right owners of record, all of the claimants that submitted claims, any registered agents for those claimants or water right owners, and any counsel of record were provided notice. The proposed determination can be accessed at the link that you see on the screen. And the accompanying hydrographic survey map can also be found, maps can be found at that link. And we can, for those that are present in the room, we can certainly help you access this if you need help. Might be a good thing to do after this formal part of the meeting is closed. For those online, please reach out to us. We can help you access that. Email us or come into the office. We're happy to help. All right, so let me get a real quick. My mouth gets a little dry sometimes. All right. So let's walk through the proposed determination, what you'll find as you work your way through that. This is a rough outline of what you'll find in there, and let's just bounce through each of these sections in turn. All right, so this is the title page. On this page, you'll find some important information. You'll find the district court that has jurisdiction over the adjudication. This is the Third District Court. You'll find the name of the general adjudication and the civil number. That civil number is very important if you're going to file an objection. Your objection needs to reference that civil number. And you'll find the hydrologic division and the subdivision name. In this case, we're in the Salt Lake County East Division and the Fort Union Subdivision. And then finally, you'll see the area and book numbers. So let's move along. This is the notice. And again, you'll see some of the same information repeated here. This is the civil number, and then the judge, Judge Laura Scott, that is proceeding over this case. And then right here, you'll find instructions on filing an objection. Objections need to be filed with the Third District Court. It's not something that we receive in our office. Okay, and so if you need help, we can walk you through, or we can give you some advice on how to do that and answer your questions regarding that. But ultimately, the objection will need to be filed with the district court. All right, the next section is what we call the preamble. In this section, you'll find some general information about the area. You'll find irrigation duties, stock watering duties, all sorts of things like that. And one important area of this that I want to turn your attention to is what we call the prior decree section. Since this area has a prior decree, the Little Cottonwood decree, the Morse decree, there's a section where we discuss how water rights are distributed, and we're effectively regurgitating what was decided in that Morse decree. It is worth noting that this is slightly different than what was previously published in the East Murray proposed determination. Since that proposed determination was filed, we've identified that our approach on some of the surplus water rights was not strictly correct and was not strictly in compliance with the decree. And so we intend to file an amendment to that proposed determination to correct that language. The East Murray, just for the information of those that are familiar with the Little Cottonwood system, the East Murray proposed determination included just a single award, the Brown Award, the Brown Ditch Award. And so we'll be amending that section to conform with what you see here. All right, let's talk a little bit more about the structure. I think you've kind of inferred this, but the awards in the Little Cottonwood decree are spread across 3 different books. As I already noted, the East Murray proposed determination has the Brown Ditch Award in it. What we just published in the Fort Union proposed determination has Tanner, Kahuna, Maxfield, Union, Jordan, and Walker awards. And so those were all part of this proposed determination. The forthcoming Little Cottonwood proposed determination will include the remaining primary and surplus awards, the North Despain, the South Despain, Greenwood, Brady 1, Brady 2, Biesinger, Van Valkenburg, and Richards, together with some surplus only awards that were in that decree. And so that's what you can look forward to when we get that proposed determination out. Okay, so let's talk a little bit more about quantification. One of the most challenging aspects of working with the Little Cottonwood Morse decree was it lacked quantification information. Many decrees include descriptions of how many acres of irrigation were done, and the Little Cottonwood decree didn't have that. It didn't define what other uses might be pertaining to these various awards. And so we did a lot of investigation, and we've come up with an approach that we believe captures the intent of the Little Cottonwood decree. We've worked with the water users, the key water users in this area to refine these positions. And for the first primary water rights, generally these are defined by existing beneficial use, or they will be. But defined by existing beneficial use or defined by prior certificates of beneficial use. Several of those first primary water rights were given some definition in 1958 or there was one that was in the 30s. There were some certificates that were issued and described what those water rights were used for historically. And so we've leaned on that in defining the beneficial uses that can be attributed to those rights. As we step into the second primary water rights, we broadened our search, and we had to dig into a lot of different sources to be able to quantify these water rights. So in some cases, there was information on the water right file that helped us determine what the historical use of those water rights. For example, some of the water rights had defined their historical use in change applications that were executed in the 1900s. Some of them back into the 1920s or 19-teens or so. And so in those cases, we relied on that. Where we didn't have that information, we identified a key document that helped us define these water rights. There's a state engineer's 20th biennial report that was published in the 1935 range, and it included a survey of irrigation practices across Salt Lake Valley and other areas. And so we were able to get acreages from that survey, and from also some additional 1934 mapping that was done of this area. And we had intended on bringing the mapping, and unfortunately we forgot it. If you're really interested in it, we can help. We can show it to you. We can send you a copy. It's very, very large. It's really hard to email. But if you're interested, let us know, and we can get that in your hands. And so between all of that, we've been able to construct a model of historical use for each of these awards that we think fits with what was likely in place in that early 1900 timeframe. Okay, another one of the big important parts of this is Water Right 5740, which is the savings or the cutoff savings ditch award. This was an early application to the state engineer's office to bypass a portion of Little Cottonwood Creek and run the water down a ditch to prevent loss of water in the creek bed. And that certificate was pretty key in our understanding of the Little Cottonwood water rights. And it defined what we view as an overall service area for all of the ditches that were affected by that, of 6,475 acres of irrigation. And so you will see in each of the awards that were party to the cutoff savings ditch that Water Right 5740 is included in the water use group for that water right. And I know that's a mouthful. I've thrown a whole bunch of water right terminology at you. If you have questions, we're happy to walk you through it and explain this to you in greater detail. Okay, so let's move along here and get into some more depth here on what you'll find in the proposed determination. You'll find a location map. This is the area that we adjudicated. It's generally, on the north, it's I-215. On the west, 7th East is the boundary. On the south, generally it's about, is that 80th South? I have a hard time seeing that. 8600 South. And then Highland Drive on the east side. All right, going further, what you'll find after those pages is a listing, what we call the priority schedule. And what this is this is a listing of all water rights in this book according to their priority date and according to their source. And so perhaps the most important part of this for the decree water right holders is those that are diverting from Little Cottonwood Creek. And so you can see there on the screen, that's the source, Little Cottonwood Creek, and then all of the water rights in order of class and priority date. A priority schedule is an important part of distribution of water. And so that I know that this is an area where we have an active distribution system. And so this is going to be important in the coming years. All right. Oh, I guess I should have clicked on my mouse button or my keyboard. So the water source, priority class, priority date. We describe the flow rate or the volume. And then we have the water right number and the owner of record for each of these water rights. All right, moving along, this is a typical page from the proposed determination. And what you'll find here is each water right is listed by its water right number. We describe the owner and the ownership interest of each water right. And then moving along, the type of right that it is. This one that you see on the screen is an application to appropriate. And you can see the quantity of water that is assigned to this water right. And you'll find the priority date and the source, and then the point of diversion. In this case, this is an underground water right, and so you'll see the well and the diameter of the well and the depth of the well. All right, moving along, this is a water use group. This is where the state engineer's office keeps the beneficial uses of a water right. Each water use group has a number that pertains to its place of use. And in this case, you can see that the nature of use for this water right is irrigation and domestic. And you can see the period of use, the sole supply of this water right, and the group total for this water right. And you can see the acreages, or in the case of domestic, how many EDUs are tied to this water right in each case. Below that, you'll see the place of use. And the place of use is described in terms of 40-acre tracts within a section of land. And so this water right, you can see is, I can't quite read that. Oh, it's on the line. That's horrible. I can't read it. You guys can't read it. But that describes the section, township, and range. And then the place of use is described in quarter sections. And those quarter sections are marked. In this case, you can't quite, you can kind of see an X in there. That's the quarter section, or the quarter section in which this water right is used.
Mike, I just have a question.
Acreage totals for the irrigation, if that applies. All right, so moving along here, some water rights also include general comments that are attributable to the water right, and they'll be listed at the bottom of the water right. All right, there's also a section in this proposed determination for renumbered water rights. And so in that case, you'll find the old water right number, followed by the new water right number. We do this when we identify, one case where we might do this is if we identify that water rights are duplicative, we'll renumber one into another and recognize all the beneficial uses under that new number. And then there is a listing of forfeited rights in this proposed determination, and they're described by water right number, the name of the owner of record, and then the point of diversion and source. All right, at the end of the proposed determination is an alphabetic index, and it's exactly what you would expect. We have a listing of the, what's that?
I have an online question to clarify this.
Oh, EDU. That's a great question. An EDU is a equivalent domestic unit, and it effectively means a single house, one house. So very good question, though. All right, so the alphabetic index, name of the owner of record, point of diversion and source, water right number, and then the page on which you'll find that water right number. All right, let's talk real quickly about the hydrographic survey maps, which you'll find there. You'll find on these maps, you'll find that we've identified the irrigated acreages of the various water rights, and they're organized by water use groups. And I know it's very hard to see here that the little smidge of pink that you see there is the irrigated area. As you can imagine, most of this is all developed these days, and so the pockets of irrigation are small and in between lots of other areas that are supplied with culinary water. And of course, north arrow scale and a map legend and a map location. This gives you an indication of where this map is within the subdivision. If you look closely, you can kind of see the outlines of the subdivision boundary and which map this map where this map sits within that area. All right, so this kind of brings us to the close of this. So if you have questions, we're here to answer those. We'll do a short period of questions on the recording, and then we'll just go ahead and close it. And we do kind of stick around for a little bit. So if people want to come over, if they haven't come, or for those that are here, we'll stick around and answer questions. If you have questions in the future, my contact information is there on the screen. Again, my name is Michael Drake, and I'm the assistant state engineer over this. We also have Ryan Broadbent. Maybe Ryan, for those in the room, raise your hand at the back. Guy in gray, and Ryan can answer questions, but everyone along the back is one of our employees, including the Attorney General, Mike Ferguson, that can also answer questions. And so with that, I think that's the end. And so I guess we'll take questions now. A little bit about supply of unevaluated sole supply is something, maybe I'll advance back or go back to that just so that people can follow where it was. I know sometimes I miss things. There we go. Result, unevaluated sole supply. Unevaluated sole supply is something that the state engineer's office uses with water rights that are supplemental with each other. And so you'll have a plot of land, and well, sometimes we use it sometimes in cases of the supplemental water rights. And so you might have a primary water right that provides for that land, but there might be another source that comes in and provides for it on occasion. And if that land is an acre in size, we may put all of the beneficial use value of the water right, meaning the 1 acre of irrigation, on one right. And we'll recognize that the other water right has a right to provide water to that on occasion, but it's not the primary water right. And so we'll describe that as unevaluated, with the full value being represented on that primary water right. Where this applies with these cutoff savings ditch water right is that award is described in the certificate as entirely supplemental with all of the first, or many, it's not all of them, but many of the first and second primary water rights. And so we've given 5740 an unevaluated sole supply of, for example, Cahoon and Maxfield. Or I guess that's a bad example because that one has been pulled out, but maybe Walker Ditch. And so we've described the acreage of Walker Ditch according to our research, however many acres that is. We've assigned that beneficial use value to the primary water right. And then we've assigned 5740 to that water use group, but given it an unevaluated sole supply, recognizing that right does contribute to that award, but it's not the primary award. The primary award carries the full value. Does that make sense?
A little bit. Maybe talk a little bit about the process of going from values acres, and how that was.
All right. Well, so we did not convert the decreed flow rate values to acre feet. We defined them so the flow values values that we portrayed in our proposed determination. What was missing from the Little Cottonwood proposal or the Little Cottonwood decree was the acreages on which those flow rates were applied. And so our research was done to identify those acreages. Does that make sense? So I'm differentiating between area and volume. The volume is the amount of water you're putting on the acreage.
You use 5 acre feet per acre as a use number.
It is being adopted as the irrigation duty in this area.
Because it used to be 3.
Yeah.
4 down in southern Utah. So why the 5?
Through historical practice and just ongoing evaluation, 5 has been we've identified 5 as the reasonable irrigation duty for the Salt Lake Valley. And now one thing, if you've been following proposed determinations, is we have been amending these duties as we get up into the canyon areas. And so through the Parley's proposed determination and the Mill Creek proposed determination, we've adopted a 4 acre foot per acre duty above, I can't remember the elevation. Does anyone remember the elevation? Yeah, it's approximately, the one of the Lake Bonneville shoreline.
So did you equate the acre feet delivered from Little Cottonwood Creek to the acre of ground?
No. Our evaluation was a historical evaluation of what those flow rates were able to accomplish. And that's where we used these different resources that I talked about. We looked to historical information that was on the file. We looked to the 20th biennial report, which did an irrigation survey back in the 30s, and then the 1934 Israelson mapping. So each of those contributed in different ways to each water right. And so our definition of acreages was not done through a duty evaluation.
Because I did a calculation just using the flow and coming up with the total acre feet, and then looking at what had been said as the sole use acreage, and even using the number of 5 acre feet per acre. Just did it for June and July, which is the second surplus, which you'd be up above it, so you would have a full surplus.
Yeah.
And our Tanner ditch has 18% of that flow. 4/18, right? Basically 18%. Using your numbers, I came up with I think you gave us the ditch 197 acre sole use acres, and I came up with close to 400, and that was just for 2 months. And so I just see a real discrepancy in I mean, we know how much water was being produced by the creek, but it doesn't tally up with the numbers that you've given it. I mean, I would just have to.
Are you doing it based on a 24/7 delivery of the flow rates?
Yeah.
Yeah. Well, and
so you talk about this for general numbers.
Yeah.
1 CFS, 2 acre feet. That sort of thing.
Yeah.
I was talking in general stuff.
Yeah, and I mean, to offer a quick comment, these surface systems are very, very complex. Flows go up and down, and I think you're using a surplus number that is really should be characterized as the maximum available, and yet that's not a flow that would be regularly available, and so.
I think for June and July, you could say it's regularly available.
Okay.
Second primary.
Okay.
So I think that's why I chose that.
Yeah.
That eliminates the up and down. It's there.
Yeah.
And your acreage, think it was 197 and 179. That was easily covered in just 2 months.
Yeah.
Double. So we're talking 10 acre feet per acre of what you said. And then that doesn't include the shoulders.
Yeah. Yeah.
And so I just have a hard time. I have a hard time thinking that it's all been added up. Another aspect, especially I'm secretary of the Little Cotton Tanner Ditches, is that our adjudication is mixed up with the Big Cotton Tanner Ditch, a very different sort of a way. We always figured that the two ditches they have, for example, we have 4 ditches in the Little Cotton Tanner Ditch. 2 of our ditches commingle with the Big Cottonwood and 2 don't. But in your memorandum of file, you state that the Big Cottonwood Tanner Ditch could supply all of the water to the Little Cottonwood Tanner Ditch, which that's not true. 2 ditches aren't supplied. So, and then when we look at the map, we stop at what looks like 5,600 south. I'm from the Little Cottonwood Tanner Ditch. We're servicing people clear over 40, past 48 south, and we're servicing. If we think about, it's also in your memorandum for file, you say that we're basically west of 13th East, but that's not really the case. I mean, we're coming in above 13th East. We're coming from Millen Lane. That's east of 13th East.
That area was included.
Well,
that was included in.
I'm following 13th East, which I can't say. Because you don't roads you can't see it.
Yeah, it's very hard.
I'm trying to figure it out, but we go to about 17. We go over it with our one branch. We go over to about 17th East, and then I look at the drawing here, and I think I can identify 13. Well, 17th and 13th, a lot of distance that's been cut off. So yeah, so I'm really kind of concerned. And then they attribute to the Big Cottonwood Tanner Ditch like 1,400 and some acres, and they attribute to the Little Cottonwood Tanner Ditch 197, which I think anybody that has been running water down those ditches knows that's really not the way it works. For example, if you were to talk to people that have farms, for example, the Erickson farm, they had 13 shares of Big Cottonwood and 35 of Little. So yeah, the top end above the Little Cottonwood Tanner Ditch was all Big Cottonwood. From 17th East on down, it was both, and below 13th East, it was almost all. And then the Wheeler branch and the Green branch are not represented on this drawing, and they don't have anything to do with Big Cottonwood Ditch.
Okay.
So I mean, when I look at it all together, I see an area, a geographical area that's greatly reduced. And you might say, well, what does that matter? Well, that matters because we have an exchange agreement with Salt Lake City, and it depends on geographical use area. So if we've been reduced to our area, even though, I mean, we're greatly reduced. So how does that pan out 100 years from now? Yeah. This is what people will look at this and they'll say, well, that's it. And this isn't representing. I think that the Big Cottonwood Tanner Ditch, the Little Cottonwood Tanner Ditch, you talk to people that understood it a long time ago, they would probably all agree that a 60-40 is about right.
Okay.
And
So if I could respond, I don't view anything of what we've done as affecting the exchange agreements that the various ditches have signed with Salt Lake City.
but
I think those are.
restricted the geographical area you have.
I still don't think that affects that. I think where you deliver is your geographical area when it comes to those exchange agreements. And now certainly if needed, this would be a good time to, I think go ahead and file an objection to put your thoughts on record. I think that is a good thing to do. We've had to make some assumptions to get to the point where we are now. And we did. The biggest assumption we made with Tanner Ditch was we assumed that lower area was 50-50 big Cottonwood and little Cottonwood. We knew that there was a possibility that was not a good number, and we didn't know for sure. We're hoping that through this process, if that number needs to be recast in one way, that we can do that. And so object. Let's get the number straight. But I do think Salt Lake City is a big part of this because they are the owner of this, and at the end of the day, I think those exchange agreements are entirely and completely enforceable as they were executed back in the day.
But the acreage, if somebody pulls up the adjudication, they're going to think that we're irrigating 197 acres.
We're portraying what the value of the water right is. Most of this is gone now. It's all being diverted and used by Salt Lake City.
If we compare the amount of water that our water right is worth compared to the big Cottonwood Tanner Ditch water right, are we 24% of theirs? I don't think so. I think we're close.
The flow rate award of the Tanner Big Cottonwood award is quite a bit larger than the Little Cottonwood flow rate award. And so the expectation is that a greater number of acres would be irrigated with that flow rate than would from the Little Cottonwood Creek. Now, some of this we're projecting way out into the future. What's that? I don't know. We can look at that.
I mean, I think that would be, even though you're not using that, I think that comparison would be a better comparison.
Yeah.
As far as saying that, well, they don't have much water, so they have about this area, which in my mind is much less than half. Show in the hatch line. Mm-hmm. It's much less than half of the area is.
Yeah. At this point, file an objection and let's take it up. Let's consider it, and we'll bring the parties together and we'll evaluate what the best position for these water rights is. This is, I mean, this is how the adjudication process is intended to function. Objections are a good thing. We want to make sure we get this right. This is a very complicated system. We had to make assumptions to get here. Our best shot is out in the open now. You can take a look at it and file an objection, and let's take it up.
Was this process, I guess, closely worked with the actual water right owners? I mean, Salt Lake City, were they involved in
yes.
how this all was developed?
We met repeatedly over the last however many years and intensively over the last few months.
Can you talk a little bit about what's referred to as that depletion value? And what is that really? What's the...
Is that a reference in the... something? I don't think I had anything about depletion in the slideshow.
No.
Are you referencing
the determination? But I think it's part of the document that supports this.
Yeah. So depletion, ultimately, water rights is, if you really go to the fundamental nature of what a water right is, it's the right to deplete and consume water. In the state of Utah, water is a public resource. And so by obtaining a water right, you obtain the right to deplete water for a beneficial purpose, whether that's irrigation, stock watering, municipal use, or whatever it might be. And it is one of the key details of a water right that we use to manage this water right system. And so if we're speaking about irrigation, there have been studies that have been done to determine what is average depletion from an acre of land. And so we apply those factors to these historical acreages that we determine to figure out what is the depletion limit of that water right. Historically, it irrigated 100 acres of land. How much water did that consume in that irrigation? Many of these water rights today are being diverted by Salt Lake City, treated and used for municipal purposes. The state engineer, in trying to better manage this, wants to manage these water rights and limit them according to historical depletion. That's why we've spent so much time looking at what the historical uses were, so that we could come up with an idea of what the depletion would have been historically for these water rights. And then that depletion is what, in managing Salt Lake City's diversions, we will use to limit them so that we're not using in excess of what was historically done under these rights. We have an interest in preventing enlargement. When water rights are enlarged, it affects downstream water users. It also increases depletion from critical resources like the Great Salt Lake. And so that's one of the reasons we're bringing depletion into the adjudication and seeking to quantify these water rights.
So even though your water right and that flow is X amount based on this idea of irrigation use, there was only so much of that being actually beneficially used. And so now that is what is being considered as the actual available amount of water today versus what your initial decreed volumes said?
Not quite how you're stating it.
Okay.
You still have the right under all of these water rights to divert the same flow rate you always did. And you have the right to apply that to the same number of acres that you always did. The only thing we've done is, using modern technology and modern studies, we've evaluated, okay, given that, how much water you take and what you use it for, how much of that water is consumed, is taken out of the system. It's lost to evapotranspiration or some other permanent loss of that water from the system. That's what we're trying to quantify. And that permits much better management of the water system. And so you still have the right to do everything that you always did under these rights. You take the same flow rate you always did out of the creek, and you apply it to the same acreage you always did. We're just applying that other layer that better defines, okay, what was this? What did this really let us do? How much water was taken out of the system by this use happening?
What is the consequence of that number now? That, I guess, is that depletion value?
It should be zero consequence, because again, it lets you do everything you already were doing. You take the same amount of water and you use it for the same purpose. We just now have this tool. The reason it's important, and I already explained this, is because we know that most of this water is being diverted and used for municipal purposes, and so we need to have a way to limit and describe those municipal purposes, and make sure that what the water that was historically used for irrigation and is now being used for municipal doesn't exceed the amount of water that historically was taken out of the system.
Right, and what was historically taken out wasn't that full value of that flow.
Correct.
It was that.
Yeah. If you go back into the early 1900s, most of this water was used for irrigation purposes. Roughly speaking, irrigation is about 50% consumptive. So half of that water that was diverted rolled off the end of the field and was made available to someone else downstream to use. So we're trying to keep that same dynamic in place.
So, okay, so then if now the municipalities are being told that what they have access to is now based on that depleted value. How does that not change what you're saying is we still have a right through our exchange agreements?
Mm-hmm.
When they come back and say, well, we no longer have that amount of flow, we are now no longer obligated to give you that full flow rate.
I don't believe that right exists. There is case law that exists that supports that premise, that is a contractual right that the city is bound to provide if and when that's desired. But this is getting far outside of the realm of adjudication, and it is getting into the realm of a private agreement between two parties. The state engineer has nothing to do with those agreements. And so when it comes to enforceability, that is something that you need to take up with the city.
Sure. I just want to understand the process of how we got, to kind of what we're now being, kind of presented.
Yeah.
So when I do have those conversations, I kind of.
No, it's great. That's why we're here. So we love to be here to help.
Another question. So you did show the Little Cottonwood subdivision, and you listed some water rights in that. I understand that we've got a Little Cottonwood that we've got an actual water right that's not tied up in our exchange agreements with the city in the Little Cottonwood determination. And I'm not seeing neither Tanner or us up there. So I'm not.
Well, I don't know. What water right are you referring to?
Well, it's a leased water right. 10% of what we have in the decree is under a lease agreement with the city.
Yeah, that will be handled in the Little Cottonwood proposed determination that's forthcoming.
So wouldn't we be listed under that, though? What I'm not seeing.
Well, in presenting this, I didn't list that water right there.
All right.
And so that'll be handled separately. So you'll see recommendations that are pertaining to that.
So I can assume that we'll get notification.
Yes.
Etc.
Yeah. Yeah, almost certainly. I think we send it to all claimants and all water right owners, and I'm positive you're a claimant within that subdivision as well, and so you'll get notice.
Okay.
Yep. No, there's a question behind.
Yeah. I'm here trying to help my father, but he's just he said, so, but it's his small little water share that he pumps. He pumped out of the Tanner ditch, and I don't even know what branch from Tanner. But then he said Salt Lake City comes to him and said, no, if you sign this agreement, you can do this all with metered water for a flat fee. And I'm assuming that's an exchange agreement.
Yeah, we could look. What's the name? I'm familiar with a few of the names.
His name is Gary Curtis.
Curtis.
He's from.
Anyone know Curtis? Any of my staff?
19.
Okay, we'll have to look at it. Let's look at it after we close the meeting. We can pull it up on the computer and we'll see what we can see. Yeah. Yeah. That is that. Yeah. So let's look at it.
Yeah, he just gave me this.
Okay. Let's look at it. Yeah, there's a reason you got it, and so let's look at it. We'll figure out why. Any other questions? Okay, maybe let's anything online? Okay, well, maybe we'll stop the recording. Thank you, everyone, for participating in this. And again, reach out to us to see if you have questions. Let me advance this to the end, so everyone's got our contact information.
Could we reach out to Ryan Rodman? He's the one that wrote it. I think he did. He wrote this memorandum.
That's Ryan right behind you.
Can we ask him questions?
Yeah, and
but I'm going to say the same thing.
and actually, I wrote a big part of that, and so we're both in the same place on these. We'll talk to you. We'll both talk to you. So, all All right. Thank you everyone again, and we'll go ahead and end the public meeting.
Thank you.
Thank you.